All right, good afternoon, everyone. We have a plea and arraignment calendar and then one add-on. Mr. Cook is here, Ms. Rockwell's online. So we'll see whether her efforts to connect with a supervisor were meaningful or not. But let's call the calendar first. Position 1 is Kyrie Rhodess.
Yes, Your Honor. Sergeant Jerome here for Kyrie Rhodess.
Hey, Mr. Jerome, how you doing?
I'm doing well. Yourself?
I'm all right. Have you filed an entry?
Yes, I have.
Great. Let me pull this up on Odyssey. We waive an arraignment today?
We are waiving arraignment. Mr. Rose is actually here.
I'll bring him out. I just wanted to know what we're doing, and then we'll bring him out and have a conversation. I want him to meet me, and I want to meet him.
All right. Yes, and we are waiving arraignment. Mr. Rhodes currently has a new pending charge that's just been indicted yesterday.
Oh, well, we know where that's going to go.
Yeah. And
what are those charges?
It's aggravated assault, cruelty to animal, possession of a firearm.
Okay. Well, that will be green sheeted here if it hasn't already. I see there was a PI number. Let's see. 007304. I guess you could waive arraignment on both. Will you be representing him on both?
Yes, I will be representing him on both. Okay.
It hasn't made it here yet. It was assigned to Judge Farmer. It was not green sheeted. So I'm just, and someone already filed a waiver. Was that you?
I filed a waiver on this case. Oh, I apologize. This morning I did file a waiver this morning.
It is a waiver, which is all good. I'll just see what, yep, here's your waiver. So you've waived arraignment on what we'll call the aggravated assault case. And that's moving forward. And you filed a leave of absence. You're in on that one. It's not linked to the old one yet, but I bet his case manager, Judge Farmer's case manager, will quickly learn, hey, we can slide that over to 8D. So here we are. You have filed a waiver of arraignment. So we can bring Mr. Rhodes out in just a moment. Anything else you wanted to talk about?
Yes, I wanted to see if we could address the FTA. I haven't filed a motion to lift the FTA, but I'm here to ask the court would.
We can start the discussion, and I'll hear from the state. If the way the discussion goes, it seems like the state ought to be given some time to research some question. I'll give them that time, but we wouldn't necessarily need to bring you back here after that. It could just be Ms. Davis would say, I've looked in the system and the answer is no, or yes, or whatever it is. So I don't mind having that discussion. We'll circle back. Let me get through the calendar, then we'll bring, as in call the calendar, then we'll bring Mr. Rhodes out. I'll introduce myself, explain what we're doing today, and then on the record, we can have the FTA discussion. All right? You're welcome. All right, position 2 is Daryl Jackson.
Yes, here, Your Honor.
Hello, Mr. Jackson. Ms. Rios, your office has the case.
Your Honor, our office, he did not qualify at the last court before.
Oh, you're right. I'm now seeing the notes. Early on he did because Princeton Hines had it. But this is for Mr. Jackson. This is an inquiry calendar and not plea and arraignment. We gave you time to hire a lawyer.
Yes.
So here we are.
Yes, I tried to contact my lawyer this morning, and but I have hired one. I have her information on my phone.
Great. Give me the name, please.
I have to spell it out to you.
That's okay.
It's EKIDEKURE.
Okay, that's the last name or the first name?
I think that's the last.
Her name is Angelia.
Okay, this is someone you know?
Yes.
All right. And you've hired her. It's not that you said someday I'll give you.
I signed a document on there.
Great.
I signed a document.
Okay.
Process of paying her name.
Did your lawyer know that you had court today?
Yes.
Okay. then what I'm going to ask you to do is step outside and try to contact her or her office to see if she can hop on Zoom. She don't need to be here in person. It's great if she could be here in person, but my guess is, being a lawyer, she's doing something else somewhere else. But if she can get on this call, I can see her and she says, I am Daryl Jackson's lawyer, then we can move this along, okay? So you can step outside, try to reach her, and she'll need the Zoom link, but we can get that to her. She can reach out to my staff. I just need her to say, yes, I could get on the Zoom. Worst case scenario, it may be that she's willing to take a call from me and I'll call her from right here. And with you listening in and the prosecutor, we'll lock in the fact that she's going to be your lawyer, okay?
Yes, Your Honor, I have one other question. I received yesterday saying something about October 7th.
Yes,
I just got that yesterday.
that's you do have court on October 7th. You have court today, so we could sort out lawyer, no lawyer, and then your next court date is October 7th. Okay? I'm glad you're getting that stuff in the mail. So let me know if she's going to join us on Zoom or if I need to call her.
Yes, sir.
Thank you. Gariana Stone.
Her preference was waived. I filed a waiver.
Okay, this is the re-indictment that includes Mr. Roberts, is that correct? Okay, oh, so position 3 should be null prost.
I submitted that, the re-indictment position.
Okay, I'll get there. I'm just going in the order of the calendar. Okay, so that has been null prost. Thank you. That's in the system. Position 4, Paul Felker.
These should be in GDC.
GDC. Oh, we have someone online too. Except I don't see a facility. I see Ms. Hemmings from the Department of Corrections. Oh, here. Oh, Johnson's iPad is a facility. Okay. Hey, are you Mr. Felker? You're still on mute. Maybe they can help you with that.
Yeah, I'm Paul Felker.
Great. Hey, Mr. Felker, I'm Judge McBurney. You have a case assigned to my division. And today was supposed to be an arraignment date. We may still be able to do that. Ms. Rios, if you get online in the jury room or something, could you speak with Mr. Felker?
Yes, sir.
Okay. Any reason to think this is not your case?
Well, it's not, it's gonna be this.
Well, not a PD's case.
Oh, no.
Today it's your case.
Yes.
And you could handle whether Mr. Felker wants to waive arraignment or be formally arraigned.
Yes, sir.
Got it. Mr. Felker, you are in GDC custody for what reason?
Aggravated assault and drug charge.
Something you pled guilty to, or it's a revocation, or what happened?
Pled guilty.
Okay, out of what county?
Cobb County and Fulton County.
Oh, you had 2 cases.
Yeah.
All right, and what's your best sense of your sentence? How long you expecting to be there?
2.5 years.
Okay. This is likely a case, assuming the evidence is there, I'm not making any judgment, then that you would be resolving while you're there. We're not going to drag you back here. If it's a simple one, if it's complicated and you want a trial and the state wants to go to trial, we would bring you back here. But just looking at the charges, my guess is after you've had an opportunity to speak with your lawyer a few times and she shared with you some of the evidence, we might be able to resolve it in this same format where we just get you online and have the necessary conversation to move it along. Today is simply arraignment day, and in a few moments, I'm going to have Ms. Rios, who is the law partner of the lawyer who's going to represent you. The lawyer who would actually take your case is on leave today, but her partner is here, and she'll just talk you through a little bit about the process. It's nothing you haven't done before. It's just arraignment day, but we do need to do that while we've got you on. Excuse me. So we'll do that in a little bit after Ms. Rios is her name, has had a chance to talk to you, okay?
Yes, sir.
All right. thanks. You can go back on mute. And in a little bit, I'll get you in that breakout room. And Angelia Lewis, Ms. Lewis? Angelia Lewis?
I haven't had contact with her.
You said you have or have not? Okay. Oof. All right. I'll do a bench warrant, but Ms. Rios, should you ever make contact with her, this is from 3 years ago. And so the fact that she's not here probably means notice went to the wrong place. But I'll do a bench warrant and we will, there had been some activity in the case that she attended. And so her absence is more recent. All right. Ms. Faria? Leila Faria?
Judge, I sent you a message on Instagram.
Okay, let me take a look. You did, and it says, oh, Mr. Luemba.
Good afternoon, Judge.
Hello, Mr. Luemba. How are you, sir?
I'm doing great. I represent Kadir Bradford.
Okay.
He should be in the courtroom, I think.
Mr. Bradford's here, but you jumped ahead of me.
I'm sorry.
That's okay. Got it. No, I just got my numbers crossed. I'm trying to figure out Ms. Faria, who, and that's not what the messages were about, I think. Let me look.
Judge, I have in my notes that there was a waiver filed.
Yeah.
August 27th, and a scheduling order was already generated for this case.
I think that's exactly right. Okay, so we don't need to worry about that one. Waive and schedule. And so now, Mr. Luemba, we are indeed on Mr. Bradford's case. Mr. Bradford, can you please come on up to the podium? All right, let me add that. There we go. Mr. Luemba, are we, it's on for plea and arraignment. Are we waiving arraignment for Mr. Bradford?
Yes, Judge, we're waiving formal arraignment, pleaded not guilty, requesting 10 days to file motions after receipt of discovery.
Okay, you'll get more than that. What will happen is I will enter a scheduling order after you file a written waiver. You can get that form, I think, from our website, but if not from the website, you can certainly get it from Ms. Nelson, because I do have your entry, but we'll need you to file that waiver of arraignment, and that'll trigger a scheduling order, which gives the state certain deadline to get you discovery, and then gives you an even later deadline to get motions filed.
Thank you, Judge.
Okay. Mr. Bradford, I'm Judge McBurney. Were you here before and we needed to get you a lawyer? I see there was a calendar before, so we've met before.
Yes.
All right. You're still at Bray Lauren Court in Stone Mountain?
Yes.
So you're getting stuff in the mail telling you to be here?
Yes.
Do you have Mr. Luemba's contact information?
Yes.
Fantastic. Does he have yours?
Yes.
Okay.
Yes.
That's going to be the main form of communication. Mr. Luemba saying, hey, you need to come to court or do this or that. We'll still mail stuff, but he'll be letting you know as well. And your bond is to stay away from the alleged victim as well as your co-defendants. Do you have personal or professional connections with any of the co-defendants? So staying away is simple?
Yes.
Okay. Your lawyer can contact them. You need to not contact them.
All right.
Your lawyer is going to get the discovery in the case. Mr. Luemba, he'll sit down with you with that so that you guys have a better sense of what's there and what's not. And then he'll tell you how things are going to move forward. Any questions for me? Okay. You do not need to come back anytime soon. We have to get that scheduling order out, and your lawyer will tell you, all right, these are the next court dates based on that. Okay? Mr. Luemba, anything else on behalf of Mr. Bradford?
No, Judge.
Ms. Davis, anything from the state?
No, Your Honor.
Will you, once that waiver of arraignment is filed by Mr. Luemba, you'll be able to get him discovery?
Yes, Judge.
Okay. So, Mr. Luemba, if you don't mind, before you shut down for business today, just connecting with Ms. Nelson about getting that waiver in, we'll go forward, okay?
All right, thank you, Judge.
Sure. Is that your only case here today?
It is, Your Honor.
All right, you're good to go. Have a good weekend.
You too. Thanks a lot.
And same for you, Mr. Bradford. Travel safely, and Mr. Luemba will be in touch. Now we're to Ms. Stone with the re-indictment, and you're saying, Ms. Rios, she's excused, you did a waiver? All right. We need to get a lawyer for Mr. Roberts. He is in the building, but was making life difficult for the deputies, so he did not get brought up. Has your office, I think Jessica Jones is someone from your office.
File a conflict.
You did?
Yeah.
I shouldn't have let Mr. Luemba go. Okay.
So this is the codependent hearing.
Right. So you can't take the case. That I know. I was hoping to tell Mr. Roberts, hey, we're going to get you a lawyer, but he was saying, hey, you're not getting me on the elevator. So he's not up here. So in theory, the paperwork you filed will cause Mr. Luemba probably to get Ms. Cabrera on the case.
No, Mr. Cabrera, lawyer knows coming.
Okay, if you don't mind. I know she's on break right now, but that would be great.
And Judge, do you know if this case will stay here? When I was looking at Mr. Roberts and his histories, I believe he's on first offender probation, 424 SC case, maybe a second case, and those were assigned to Judge Ingram.
So we can only transfer if it's an open case. So if someone has already pled or gone to trial, we don't get to transfer it. So if Mr. Roberts had an indicted, unresolved case anywhere else that's older than this, and it would be older than this because this is real new, then gold star for you, and you can go home early because we get to transfer the case.
Okay, I think we might, so let me just do a little bit of research, because there's 224 SCs, I know one was first offender, I don't know if the other one was resolved and if it was assigned.
Okay.
There's quite a few cases.
Yeah, he's got 2 cases.
She has 2 what?
2 cases left.
Okay.
And he's on probation 2 cases.
Okay. Well, to check anyway.
No, both of those were doing.
Oh, okay, but he's on probation.
Okay, so he pled to both and is on probation. That may be a revocation petition that's coming based on this.
Yeah, he's already in more status.
Okay, so he shouldn't be able to bond out on this then. Good. Maybe that's why he was sour. I don't know.
And there's 2 other PI cases that are out there too.
For him.
Yeah.
Is this the case where like Ms. Stone is allegedly basically fencing some property? Like she said, hey, I've got this stuff, and either said, I'll give it back to you for some money.
Oh, well, he did, so he kind of, yeah.
Yeah, and then she said, well, there's more to it, and then all of a sudden now Mr. Roberts is indicted as well.
Yeah, her part is the PayPal part.
Yeah. Okay, got it. All right. So yeah, if you could reach out to Ms. Cabrera, Ms. Rios, that would be great. Position 10 is Mr. Sinkfield. Are you Mr. Sinkfield? Good morning.
Hello, Judge Beverly.
Good afternoon. That's right. Hey, Ms. Taylor, do you represent Mr. Sinkfield?
I do, Judge.
All right, Mr. Sinkfield, if you will come on up to the podium, please. Give me 1 second. Excellent. You have an older case, and I just wanted to make sure that Ms. Taylor represented you on that as well. It's always easier, one lawyer, multiple cases. So good afternoon, Ms. Taylor. I'm looking in the docket here, and you've already waived arraignment. That hit the docket 2 days ago, and we've got your entry of appearance. So I think we're good to go. Mr. Sinkfield, did you get something in the mail telling you to be here?
Yes, sir.
Okay. Let me see. We got. You live on Lee Street in Decatur? All right. And your bond order just says you can't possess a firearm, which would be a crime anyway. Ms. Taylor, anything you want to add? I think we're good to go based on the things you filed.
Judge, no, as you see, we filed in a waiver, so we are waiving formal arraignment on Mr. Sinkfield.
I guess I have a question for you about scheduling. This case looks pretty simple. There could be all sorts of complicated Fourth Amendment angles, but it's simply possession of a firearm by a convicted felon. He's got the other case that's fairly far along, for which you also represent him. And the question is, assuming Ms. Davis, the prosecutor, can get you discovery pretty promptly on this case, if we could have them move along together rather than staggered by a bunch of months.
Yes, Judge, that's perfect.
Okay. Then we'll do that. So we'll just have the scheduling order match up. And Ms. Davis, if you just let Ms. Nelson know if you're having any discovery issues with this one, then we'll need to slow down the other one. But what I'd like to do is have this one catch up to the other one. That's okay.
I think we're down, Judge, for, if I'm not mistaken, a final plea, maybe October the 8th, I think.
You're exactly right. In the afternoon of the 8th. And so we would see you and Mr. Sinkfield again, and maybe you've been able to work everything out by then. But if not, we can keep it moving. It's not on a trial calendar until January. So there would be time if for some unfortunate reason things aren't worked out, for everyone to be ready for trial on either of the cases in early January.
All right.
Well, good. So we'll do that. Mr. Sinkfield, do you have any questions?
No, sir.
Okay, you understand 2 cases. Ms. Taylor's got them both. I will see you again on October 8th. If you haven't already, you should very soon get something in the mail telling you to come to court. It'll probably only list one of the 2 cases, but we'll be talking about both cases when you come on in. But more importantly, Ms. Taylor is going to be getting with you before then to say, here's what we're looking at, and strategize with you about what you're going to do, okay? All right. Ms. Taylor, if you have nothing else on behalf of Mr. Sinkfield, you're good to go.
Thank you, Judge. Have a good day.
You too. And Mr. Sinkfield, you're free to go. Thank you.
Position 6, so showed up.
Oh, all right. Well, that was the end of the calendar. So let's go back to position 6. Ms. Faria? Hey, how are you? I'm well. I appreciate you being here. I believe your lawyer took care of some paperwork, which means you are going to be able to go. But let me pull this back up, make sure I'm not missing anything. Yeah, so she filed a few weeks ago what we call a waiver of arraignment. You were here in early August, but I think we needed to get a lawyer for you. That lawyer's been assigned. Has she made any outreach to you? Okay, I'm going to give you her contact information. I should just print up. I need to have her leave me a stack of cards. I hand this out a lot. you should give her a call. And she's on leave right now. She would have been here today, but she has scheduled leave. And because she had leave, she took care of filing the appropriate paperwork in advance. But the miss was she should have let you know, hey, I covered it for you. You don't need to be here. But she's got a bunch of clients, and I'm sure she did not intentionally skip that 7873. All right. Ms. Cabrera is her name, and that's her phone number. It's a funky area code, but I promise you she lives here. And so give her a call, and she'll reach out and let you know what's coming up next in your case. All right, take care. All right, so what I'd like to do is have Ms. Rios, if you could go into the jury room and log on. When I see you logged on, then I'll put you and Mr. Felker into a breakout room. Okay, you need to get in there. All right, I'm gonna create the breakout room. So Mr. Felker, you're gonna be moved into a private space where only you and Ms. Rios can hear each other. You'll have your conversation. When you pop back out, we'll be able to handle your arraignment, okay? You'll need to unmute when you get in there, but you can manage that. All right, they're in. Ms. Gladden?
Yes, Your Honor, I was just hoping I could approach briefly with Ms. Davis. To speak to you, I just very briefly, I'll take like 1 minute.
What are we going to be talking about? I can guess, but.
Yeah, well, probably, well, that's what we're going to do.
Okay. Any reason we can't talk in this setting? Okay.
I was hoping that the court had some direction, if there are any changes to be made on the order, or to remove Mr. Perry's ankle monitor.
Can you give me the case number?
Yes, hang on. 24 SC 002244. We were here on August 18th.
I trust me. I remember you and Mr. Perry, in particular, Mr. Perry, and
I want to apologize, Your Honor.
you don't have to apologize for anything. I could have sworn you sent in an order.
I did, and it was like a few days later, and I haven't.
I wonder if it went in. Hold on one sec.
I sent it first as a PDF accidentally, and then I sent it in Word, but I sent it to
Ms. Nelson.
Nelson,
Yeah.
I'm sorry. Long day, Judge. Ms. Nelson? She's in the back. Oh, she's in the back.
She's here. She is always here, either virtually or physically.
Yeah.
Don't worry. Gosh, I could have sworn that I did the order, because I think there's also one from Ms. Taylor, but let me just check one other place. Bizarre.
Yes, so that I didn't send it, of course, directly to.
No. And she got it to me. I have no doubt of that. And so I will look into that today. Mr. Perry's going to be just fine, but I understand he wants it off. I ought to.
Be on the receiving end of.
I bet you are. I bet you are in the way that Ms. Nelson often is as well. So I will look into that. You should know, as in you ought to know, that you and Ms. Taylor and Ms. Davis are all on the consolidated trial calendar that starts not on Monday, but the following Monday. I don't know that this case has been on there before, but you'll get an email. It'll actually come from me, but that's just a coincidence. It's because I manage that piece. It's not because it's your case. If your case is on the short list for the judge who runs that, it probably won't be for the first week, but it'll probably bubble up the second week.
Yes, Your Honor, I'm sure that we are probably ready to be reached.
Well, it's not the age of the case. It actually has to do with other judges and how many opportunities they've had to resolve cases. And so don't worry about the formula behind it. I just want you to know, you should not show up in courtroom 1D a week from Monday unless you got an email saying show up, and do that. So if you get nothing via email, we're not able to get to this case. But if we do get to it, Judge Emerson is authorized to say only no to requests for continuances. So everyone needs to be ready. If for some reason it's resolvable, I can take the plea. You don't have to wait till then. Judge Emerson can also take the plea. It's just those Mondays are pretty hectic in there. So.
I know there's a calendar call. We're supposed to, is that the same day? I didn't even kind of look at my calendar.
No, there is no calendar call. There's an email that goes out to the 5 or 6 cases that are supposed to report to 1D that first Monday. And there'll be another email that goes out for cases that are supposed to report the following Monday. I think Mr. Jerome, you've been through that process. He knows how it works. So you'll get an email. It just coincidentally, it comes from me. But I don't have anything to do ultimately with the running of the calendar. It's just Judge Emerson has asked to not have to be involved with figuring out the order in which the cases go. The way they're ordered in that email is how he calls them out. Okay?
And Your Honor, thank you so much for looking into that. And that's all the business I have before the court today. May I be excused?
Yes, ma'am.
Thank you, Judge.
All right, take care. All right, Ms. Rios, you're already back. You and Mr. Felker spoke?
Yes, sir.
All right, I am gonna add him to the spotlight there. And you, Mr. Felker, can you unmute again?
Yes, sir.
Oh, you did, great. And can you slide over a little bit, Ms. Rios? Excellent. Ms. Rios, is Mr. Felker waiving arraignment?
Yes, sir.
All right. And to repeat, Mr. Felker, Ms. Rios won't be the lawyer who works most directly with you. She's the partner, Ms. Wood is the name of the lawyer who is not here today. She'll be back early next week. And once she gets discovery from the prosecutor, Ms. Wood will be reaching out to you to talk about the facts and circumstances of your case, okay?
Yes, Your Honor.
Any questions about any of that?
No, sir.
Okay. Ms. Davis, any reason why discovery would be complicated in this case?
Not that I know, Judge.
Okay. Ms. Rios, anything else on behalf of Mr. Felker?
No, Your
All right, Mr. Felker, where are you? What facility?
Johnson State Prison?
Okay. All right. And you're saying 2.5 years left?
Yes, sir.
Okay. Excellent. Well, thank you, Ms. Hemmings, for lining things up. And Mr. Felker, you are good to go. So, Ms. Rios, will you be filing a waiver, or you'll just make sure Ms. Wood does?
Because I don't want to put it as my case.
Good point. And your name on it, heaven forbid you get an extra case. So, all right, just please make sure Ms. Wood takes care of that.
Okay.
All right, we have
And
a,
I'll put her screenshot of your email because she doesn't have access to her email. Next.
she can text, but
Yeah.
not, you sent her a screenshot of that fun email this morning saying, be ready on Mr. Johnson on Tuesday. I have heard nothing from the state on to it, nothing. I know Mr. Abate's alive, but someone from the DA's office needs to figure out who is going to be here Monday morning. It's not even a, hey, I can't be ready. It's just nothing. Ms. Fagan has sent in voir dire. Well, you were on that email. I look forward to working with all the lawyers who show up on Monday morning. Maybe you can try your first murder.
Oh, I think that would be really impressive.
Mr. Jackson, what did you learn from your lawyer?
So out of town currently right now, Your Honor. And what the problem is, so you said I only get paid once a month. I just got paid today.
Okay.
So I was supposed to be sending her a payment, but I can't. She's, as far as what I heard, she's out of town right now, and I was trying to make my first payment I
Okay,
have a signed document that I can show the court, if possible, to show you that I have retained her.
okay.
That's my attorney, so I'm trying to pay her.
Is she telling you that until you pay her in full, she's not going to do anything?
She said that I have monthly payment.
You can pay installments.
Yes, sir.
And as long as you're good with your payments, she'll be here in court doing what she needs to do.
That's correct, sir.
Okay, have you made the first payment yet?
I got paid today. I'm trying to make a payment. I can't.
Got it.
Right.
So you are financially able to make that first payment.
Yes, sir.
It's just you and the lawyer, excuse me, haven't been able to connect yet because she's saying she's out of town.
Yes, sir.
Okay. Can I have that last name again? E-K-I-P or D is the fourth?
The last name is EKURE.
Oh, that was the first name? Was that other?
Yeah, that was the first name.
Okay. E-K-I-P is the first name?
EKIB.
B, okay. And then the last name starts with what three letters?
EKURE, so Ikure.
It'll look it up with less than that. Ekibosolo Ikure. All right, went to North Carolina Central.
I worked with her in DeKalb County.
Okay, of course, has no contact information in the bar directory. It's bad practice. Okay, Ms. Ikure. So Mr. Jackson, if you could email to Ms. Nelson, that's my litigation manager, that screenshot or letter or whatever it is you have. Okay, and her, I'm gonna write out her cards. That looks empty. I don't need to broadcast her email, but I'm gonna get you her email address. I need you to send her whatever it is you've received from Ms. Ikure saying, yep, I'm your lawyer. We just gotta make that first payment, whatever it's gonna be. Okay? And then we will reset this one last time. And by that time, Ms. Ikure needs to have filed an entry saying, I'm the lawyer. And she may say, and I'll take care of waiving arraignment. That's the simple part. And then you don't need to come back until we're having a motions hearing or your case is working out. I'm looking at your charges here. I don't know exactly how that'll play out. And that's probably not going to be your case, Ms. Davis?
No, it's not. That will be this Clark's case as of right now. I have been texting with her, so she's just waiting to see who's the assigned attorney so she can get discovery over to them.
Got it. Okay. Excellent. Let me check one more thing. Okay. So if you'll forward that email before you go, once I get word that Ms. Nelson's received the email, then I'll excuse you.
Okay.
All right? Thanks. What were you doing in DeKalb with Ms. Ikure?
Be there for 2 years.
Okay.
I started here, we worked there for 2 years, and then came back
So she was a public defender with you in DeKalb.
here. Yes.
How long had she been there?
We started at the same time, so we both were there for about like two years.
Okay.
Now she's been doing private criminal the last couple of years.
Got it. So I think what's left, we'll do Mr. Rhodes and the discussion about the FTA and then Mr. Cook. He's good. He'll come back. So we'll do Mr. Cook's if it's going to be a plea.
And Ms. Rockwell said she was on her way here when I spoke with her, and it was like 12:40. Okay, yeah.
So they're talking. All right. And you all are here. Are you here for Mr. Rhodes? Great. Okay. Then when you're ready, Deputy Gordon, if we could bring Mr. Rhodes out, please.
Yes. I'm leaving 5.
Bye. And are you available to prosecute the Tuitt case if no one shows up from the state?
Me? That's the thing.
I just need a lawyer.
Yeah, and I'm guilty.
Yeah, exactly. Ladies and gentlemen, I urge you, acquit this man. Yeah, we'll have Mr. Rhodes up at the podium. Ms. Rockwell, good afternoon. You're next. This is not going to be real long, so don't go far away.
Said Rockwell already.
Okay,
I was going over his rights, y'all.
great. You keep doing that with him, and we'll get you in here.
Thank you.
Good afternoon, Ms. Rivers. You good to go?
Good afternoon. Yes, I am.
Great. We're going to get on the record. This is 24 SC 006456, State versus Rhodes. Mr. Rhodes is here in court with his lawyer, Mr. Jerome. Ms. Davis is handling things for the state. Good afternoon, Mr. Rhodes.
Good evening.
Good evening. We are going to talk a little bit this afternoon about you missing court, why it happened, and if I should set aside what's called a bench warrant. It's one of the things holding you. I don't know. Mr. Jerome, does Mr. Rhodes have bond in his other case?
No, he does not. So we're also going to need a bond on that case.
Okay, which currently is a Judge Farmer matter. Eventually it'll be here, but I wouldn't be able to address bond today in that because I technically don't have jurisdiction over the case right now. But let's talk about this case and Mr. Rhodes missing court, and let me provide some setting. It looks like, I don't think it's going to show hearings on this screen. There, I guess it would have been plea and arraignment in February of this year, Mr. Rhodes. So the first time you would have been with me on this case, which is a driving offense. You missed court. I don't know at that point that Mr. Jerome was handling your matter. Doesn't really matter. But you weren't here and there wasn't someone explaining why you weren't here. So I issued a bench warrant. That's one of the things keeping you in jail right now. Mr. Jerome's going to tell me why I should set that warrant aside. I'm going to hear from the prosecutor as well. And then I'll let you know which I'm going to do. Okay?
Yes, sir.
Mr. Jerome. Thank you, Your Honor. Mr. Rhodes was arrested in 2023 on these charges. At that time, he gave an address in East Point where he was residing with his mother. That address was condemned in 2024, at the end of 2024, and they were forced to move. At that, Mr. Rhodes did not update his address, so we are going to take responsibility for that. He was transient from that point on. He temporarily went with his mother to his aunt's house. His aunt did not want him to reside there, so he left.
Did not want Mr. Rhodes to reside there?
Yes.
And what about mom? She wanted neither of them, or just not Mr. Rhodes?
Just not Mr. Rhodes. His mother was still staying there.
Okay, so the sisters were able to stay together. Mr. Rhodes had to find his own space.
Yes.
Okay.
And so for a few months, he was transient and he didn't have anywhere to stay. He was homeless.
And this would have been in early 25 or still late 24?
Early 25.
Okay.
25, yeah. And so until he got his own place, he didn't have anywhere to stay. However, unfortunately, the court date was in, I believe, February of 2025, and he didn't receive notice. I don't see that the notice was returned in the system. However, you know, he's willing to, you know, proffer up to the court whatever information you want in regards to that. He didn't receive notice. He didn't purposely miss the court date, and he's just asking that the court lift the bench warrant. He does have a stable address now that he can provide the court, and he'll ensure that he appears to any future court dates.
Okay. Let me look. So, what was the address, if you remember, that was in East Point that got condemned? You remember even the street it was on?
1019 Jefferson Avenue.
Okay, got it. That's where notice was sent in February of this year, telling you to be here for plea and arraignment. So it sounds like it got sent to an address that no one can be there anymore anyway. And then you moved out for a little bit, and that was to stay with your aunt, but
I never got to make it there. She told me by the age she was only allowing my mama's younger kid. So I was standing behind East Point train station on the bridge.
okay, so you were, in her mind, too old, or for whatever reason, Mr. Rhodes isn't welcome in your aunt's house.
Yes, sir.
Okay, but now you've got a stable address.
Yes, sir.
Tell me a little bit about that. Who is there?
My mother, my daughter when I'm there, my little sister.
Was it your mom who just walked out of the courtroom?
No.
No, who was that?
That was my girlfriend.
Okay, but the house where you would be able to stay is it's your mom's house?
Yeah, she sold the house. She was forced to sell the house in East Point, and she bought a new property in Union City.
Okay, so a Union City address, and it's a home, and your mom owns it.
Yes, sir.
And in the home is your mom, and then you said your sister, who's right here?
Yeah, and it's 8 of my siblings.
8?
Yeah, 8 of us that stay in there with my mom.
That's a lot. What's the age range of the siblings?
I'm the oldest. So
How old are you?
21, 16.
What's the youngest?
My baby brother Gavin, he's 4.
4. So, and it's with you there, it's 9 kids, or with you there, it's 8 kids?
With me there is 8.
You're the oldest, and then the 8th would be Gavin at age 4. Your sister here is somewhere in between there.
Yeah.
Okay. And then the person who just walked in is your girlfriend.
Yeah.
Does she stay in that household also?
No, she's with her parents.
Got her own place. Okay. Got it. And your mom has said to you, you could be at her place.
Yes, sir.
Okay. So if you're 21 now, you were 21 when some of this stuff was going on in terms of where you're staying. Have you been working?
Yes, sir.
What kind of work?
Before the beginning of this year, I was working for the city of East Point. When we was forced to move from East Point, I couldn't no longer work there because I had no transportation. I moved to Union City, and I was just working for DHL warehouse before this situation occurred.
Okay, and when you say this situation, meaning you got arrested?
Yes, sir.
Okay, and when you got arrested, was it because of this bench warrant, or was it because of the new charges that you have?
No, when they came out there, they was running names because of the noise complaint in the neighborhood, and then they was telling everybody like they had to run everybody's name. When they ran my name, it came.
This warrant popped up.
Mm-hmm.
Okay, Mr. Jerome, the newer charges that are with Judge Farmer right now, is that involve an older incident that only now was indicted, or is it recent alleged conduct?
It's recent alleged conduct. The noise incident that he's referring to is actually the incident that he was arrested for.
Okay, so they're running names. He already had a warrant, this warrant, but they also, in doing their investigation, whatever leads to aggravated assault and cruelty to animals, that was the noise that was bringing law enforcement to the scene.
Correct.
Okay.
No, that's not.
No.
No, okay.
It was a different date.
Yeah, that was, they said from March.
Oh, whatever you're charged with in the newer case was a March situation. What month are we talking about when they just ran names? And
This was the 4th of this month.
okay,
When
so,
they ran names.
all right, so you've been in for about 3 weeks.
Yeah.
Okay, so you already have how did you get out with the, did you get arrested for the March situation?
No, I never even knew it occurred.
Okay, and I don't want you to talk about the facts. I'm not trying to ask you to talk about the facts, but
I was about to say I never even knew about the situation.
about the charges.
Yeah, it just occurred. They popped up when they ran my name.
Okay. All right. Well, Mr. Jerome's going to help you navigate that. I'm just trying to understand the sequence.
Yeah.
Bottom line is you got a home to go to. Your mom will let you stay there.
Yes, sir.
How do 8 kids and your mom fit? Is it like a 12-bedroom house?
No, it's a 5-bedroom.
Oh, it's a pretty big house. Okay.
Decent.
But there's not a Kyrie Rhodess private suite. You have to share space with people?
with my younger brothers.
Okay. All right. Ms. Davis, your thoughts about setting aside, all we're talking about is setting aside the bench warrant, not what do we do with the other case or anything like that?
I understand, Judge. My thoughts are not to set aside the FTA. While my argument is not necessarily related to the FTA, one of the conditions of his bond on this case before you was no weapons. And the allegations in the other case do involve a weapon. And so that would be a violation of the bond conditions that he signed or that were issued on May 22nd, 2023.
Got it. Let me look. I may say the name wrong. Tatiana Rhodes, that's your mom?
Yes, sir.
Okay. I just need to check a couple things and we'll keep going. Who is Keisha Graham to you? Is that someone you know? Does that name ring a bell?
No, sir.
Okay. All right. So what I'm going to do, Mr. Jerome, is table your request for now, and I will revisit it in one of two scenarios. One, you end up getting a bond for Mr. Rhodes in the other case, because in some ways it's moot. Right now, there's no bond. I just saw the no bond order in the other case, but you're going to address that, and it may be Judge Farmer, or if it gets transferred here, I decide that bond is appropriate. Then the bench warrant actually has real teeth. Right now, I could set it aside, and as you candidly acknowledged, Mr. Rhodes is still stuck. The other reason that I would address it would be as you learn more about the newer case, if you, I want you to have an opportunity to talk about why I shouldn't have the same concern that Ms. Davis has, which isn't addressing head on the question of why did he miss court, but it would be you should revoke his bond in the driving case because Mr. Rhodes, since he was put on bond and told not to have any weapons, was arrested for shooting a dog 3 times. And the dog part is bad, but it's the having the gun and firing it that would be a violation of the bond. I'm not revoking his bond right now because there's not a motion in front of me to do that. It might be coming, but I don't want you to be stuck flat-footed saying, well, I know a little bit about the other case. I don't have discovery in the other case. And so what we have is a warrant, and that's it. Either of those two reasons would be enough for us to talk more about setting aside the bench warrant. You get a bond in the new case, and or you are in a better position because you got discovery to say, you know what, here's why it's not a reason to revoke bond in the old case, the allegations in the new case. Does that make sense?
Yes, it does, Your Honor.
Okay.
And in the case we do get some new discovery that I feel would be helpful, we'll just file a motion to recall the bench warrant.
Right, exactly. And then reach out to Ms. Nelson and we'll pop it on any calendar, next available calendar. And then you can be here, and we'll get Mr. Rhodes over here. Did you have more you wanted to add, Ms. Davis?
No, Your Honor.
Okay.
I know you're gonna ask me a question, so I'm just still sitting.
Okay. Mr. Rhodes, did you follow what I was saying? Do you have questions about what I said?
I kind of understand. I was just trying to catch the grasp, but.
Okay. Well, I'm gonna let Mr. Jerome speak with you back in lockup in a minute, but I'll try to do a better job more briefly. In some ways, it doesn't matter what I do with your bench warrant, because in the new case, you have no bond. And so I could say, you're right, Mr. Jerome, and set it aside, you're still stuck. If you end up getting a bond in the new case, and it's one you could make, but I'm making it up, but it's a $5,000 bond, and your family could put up the $500 or whatever it would be. Then I told Mr. Jerome, let's talk again about setting aside the bench warrant. But for now, in some ways, it doesn't matter what I do with it. But I added this piece. I'm now a little nervous about whether keeping your old bond in place makes sense because of these new charges. The only charges, you got the presumption of innocence, but I need to be thinking about, oh, wait, allegedly, while Mr. Rhodes was on bond for this old driving case, he was firing a gun. And that's inconsistent with being on bond. I'm not making that ruling yet because Mr. Jerome is entitled to get more information so he could push back and say, you know, first of all, it wasn't my client, or it was self-defense, or it wasn't a gun, it was a squirt gun, whatever it might be. He might say, you know what, we need to resolve these cases. I don't know. He is entitled to get that information, think it through, and talk to you about it.
Okay.
Okay.
I understand that.
What we'll do here is get a scheduling order out because you filed the waiver. So the next thing to happen in the older case, which is the only one assigned to me right now, but the other one's coming here, will be to get a scheduling order out. We're going to reach out to Judge Farmer's team because it makes sense to move cases together.
Yes.
And that scheduling order would apply to both cases. That puts the onus first on the state to get you discovery. It's not 10 days from today that you have to file motions. The scheduling order includes a deadline for filing motions that's tied to the state's deadline of getting you discovery. It has all the operating instructions you need, and we'll go from there.
Okay.
All right?
Thank you, Your Honor. May I be excused?
You may. I think I got the text from my, hold on. I got the email. Okay, I see it. It's a little confusing what it is, but it looks like through Dropbox. She sent you the letter, you signed it, and you guys are good to go. Okay, all right. You'll get something in the mail telling you to be back here. When you are back here, your lawyer either needs to be with you or online saying we're ready to roll, okay? All right, take care. Oh yeah, did I confirm we got a good address for you, Mr. Jackson? I did, all right.
Line is saying. You have microphone turned and bridge till present. This is second operation. And then you follow my application. It's found on his long term. Right.
Mr. Cook, just like last time, you should sit if that's more comfortable, or you should stand. Our conversation will probably be, well, it's Ms. Rockwell, it could be more than 10 minutes.
No,
But,
because I'm just gonna ask you to remember everything that we talked about yesterday.
okay, all right. Then come on up. But if at any point you need to sit, just tell me, and that's fine. It's not mandatory standing, okay?
Yes, sir.
You just need to be near a microphone so the court reporter can hear you. But you don't need to lean in, that microphone bends. So you get however comfortable you are, and Ms. Rockwell will bend the microphone.
Hey, you wanna sit down or you wanna stand right here? Which one?
I'm standing here.
Because I wore you out today, back
Yeah.
in and out.
Yeah.
Where do you want? You wanna sit down right there or right?
I'm sitting.
Okay,
I'm sitting.
perfect.
Okay, you go over there, sit in the middle. You just slide on over or sit in the middle chair and bend that microphone down towards you. All right, let's get on the record with Mr. Cook, which is 24 SC 001-619 from our trial calendar. And Mr. Cook is here in court with his lawyer, Ms. Rockwell. We've got Ms. Davis from the state. Ms. Rockwell, is this a plea that we're doing now?
It is, Judge.
It is a plea. All right, Mr. Cook. You are going to be put under oath in just a moment. Once you're under oath, all your answers need to be truthful and complete. If you have any questions while we're going through the process, let me know. Wave your hand or say, wait, I'm confused. And either I'll try to answer your question or you and Ms. Rockwell can have a private conversation, okay? All right, make sure you speak up so that court. All right, don't move the microphone again. Just speak up. Yeah, so that Ms. Rivers can hear you. All right, Ms. Davis.
Please raise your right hand. Mr. Cook, thank you.
Yes, ma'am.
Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
I do.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Junior or senior?
I'm a junior. Senior is my father. He's passed away.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
1 second.
Mhm.
Do you take medication?
Yes, I do take it.
Okay, you can tell her that it's prescription.
Yes, I do take it. I did have taken it today.
All right, but you got it. So the question was, do you take any medication?
She kind of scared me, but she said, do you take any medication that
Sorry.
you haven't took today?
Oh,
I
well,
have took it today.
tell me what medicine you normally take.
I take oxycodone 20 milligram, and I get a 5 milligram patch of fentanyl.
Really?
Yes.
Just, you're working through a lot, but it's prescribed fentanyl.
Dr. Walgreens give it to me.
Okay. Oxy and fentanyl.
Yes.
All right.
I got it right here in my
And
phone.
that's why, Judge, we didn't know if he was gonna be a good fit for accountability court.
That would be a complicated one.
Right, yes, sir.
All right.
How old are you and how far have you gone in school?
I finished school, but I'm 47 now.
When you say finish school, you finished high school, college, law school?
I finished, I had got a GED.
You got a GED.
Mr. Cook, are you a United States citizen?
Yes, I am.
Do you understand that you're charged with the following offenses in indictment 24 SC 001619, possession of methamphetamine with the intent to distribute, possession of a firearm during the commission of a felony, and possession of a firearm by a felon?
Yes, I do.
Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I do.
Have you had enough time to speak with your lawyer, Attorney Rockwell, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No, I do not.
Are you satisfied with her services?
Yes, I am.
Attorney Rockwell, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
So waived.
Mr. Cook, do you remember being arrested on these charges?
Yes, I do remember.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Rockwell, are you aware of any outstanding warrants related to this case?
I'm not.
Mr. Cook, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes.
For possession of a methamphetamine with the intent to distribute, it is a minimum of 5 years, max of 30 years. Possession of a firearm during the commission of a felony, it is 5 years consecutive. For possession of a firearm by a felon for your second or subsequent offense, it's 5 years to 10 years. Okay?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am, I do.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
I do understand.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
I do understand.
Do you understand that you're not allowed to possess or use a firearm while on probation?
I do understand.
Do you really, really understand it? Because you keep getting arrested with guns.
I ain't never had nothing going on my person. I ain't had no gun.
All right, well, I guess we'll talk about this case.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'd be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, I do.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask you, do you understand, okay?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I do.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am, I do.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I do.
How do you plead to the charges in indictment 24 SC 001619 to possession of a methamphetamine, possession of a firearm during the commission of a felony, and possession of a firearm by a felon?
I plead yes.
And Judge, we're just gonna speak to that. We're gonna ask the court to just accept a plea under the Alford case.
Okay.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea under Alford?
No, ma'am.
Okay. Is it your decision to waive these rights and enter this plea because it's in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, ma'am.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show at trial that officers with the Atlanta Police Department had been observing the property of 1094 La Rosa Terrace in Southwest Atlanta, Georgia, in Fulton County. Based on their observations of the property, they submitted and obtained a search warrant of that property, and that search warrant was approved on July 1st, 2022. On July 14th, 2022, the officers executed that search warrant on that property. During the execution, officers observed a group of individuals hanging out in the front yard. These individuals, officers believe, were used to direct and assist new customers with purchasing drugs. 2 individuals attempted to flee the location when the officers arrived. One of those individuals being the defendant, Mr. Anthony Cook. Officers located, after executing the search warrant, an assortment of drugs in the first bedroom. Also, officers were able to locate a firearm in that bedroom. The GBI confirmed that there was 28.26 grams of methamphetamine that were tested. The GBI will oftentimes just test one substance, but there were other substances located in that bedroom. Individuals that were on the scene but were not charged identified the defendant as that being his place where he goes. I believe it was a rooming house. So there is a lot of individuals who are on that property, but they attributed that room to Mr. Cook. One of the things that I tied or connected Mr. Cook, the defendant, to that bedroom were a pill bottle that had his name on it. Also, there were some car keys which were belonging to a Chevy Trailblazer that inside that Trailblazer had the defendant's identification card. And so that's how they confirmed the reports of that being Mr. Cook's area. The state has been in long talks, in particular with defense counsel, regarding the defendant and his condition. Not sure if jail time is appropriate, but Mr. Cook does have a history. We have agreed to an 8-year sentence to serve 1 year. However, it's my understanding that the defendant was sentenced or revoked on probation to 16 months, but that 16 months was served on house arrest. I'll defer to the court on how they, the court wants to interpret that, but the intention was to give the defendant credit for that time. While the defendant is on probation, of course, he would need to forfeit any guns that were seized. It's my understanding that that location is attributed to the defendant's grandfather. So I don't know if he still has reason to be there or if he inherited that property or not. If he does not have any ties, we would ask that he stay away from that location. It was a hotbed of drug activity.
Okay.
And we're also not asking for drug and alcohol evaluation and treatment. We can add that condition, but I'm not sure with what he's taking. I don't know how that works.
I understand.
Okay.
I think it makes sense. I think that drug court would be great. It would be complicated because of the physical disability. It would be extra complicated, and they would probably have to say no, thank you, because of the medication you have to take. And it's not your fault you have to take it, but you would fail every UA, and not because you're doing anything wrong, but because the doctors prescribe those painkillers. And so we would never know, hey, is that fentanyl he's supposed to be taking or something else going on? And so treatment might be a wonderful thing, but it's not going to come in that form.
And Judge, we also filed a recidivist notice. We are withdrawing it for consideration for this plea.
All right. Got it. I was looking at, I think we have Ms. Hardy from pretrial. Hey, how are you?
Wonderful.
Good. Happy Friday.
Friday. Did you want the full history for this defendant?
No, I got a summary from your colleague yesterday, 31 cycles and some older felony convictions. I am interested, if you've got it, the 2 most recent arrests.
They were in 2018. One was burglary, and the other one was criminal attempt to commit a felony and possession of tools for the commission of a crime.
And those aren't convictions, those are arrests?
Those are convictions.
Okay, no, my question was, what are the 2 most recent arrests? So cycles from the GCIC.
Okay, one moment. So the last arrest out of Walton was July 3rd, 2024 for a probation violation. And before that, there was that was July 26, 2022 out of Rabun County for theft by taking.
Rabun County. Okay. Thank you so much.
You're welcome.
What were you doing in Rabun County?
Where the casino at?
What did you take from the casino?
I didn't take anything.
Yeah, you never do anything, do you, Mr. Cook?
Anything didn't ever happen. It happened down the street from the casino.
Okay. And then the Walton violation of probation, I think that's what we've been talking about. But why were you arrested in July last year?
I had, Walton County had put a warrant on me.
Oh, and they put the warrant based on this case?
Stop with no headlight.
Okay, so you got pulled over and didn't know there was this warrant out of Walton, and the warrant was based on you catching these charges while you were on probation out of Walton?
Yeah, they said I never reported to.
Oh, you did a couple things then. Okay, all right. So, Ms. Rockwell, I do recall much of what you shared with us yesterday about many of the complications in Mr. Cook's life that he has had since having a real tragic situation and a rather miraculous rebound from, instead of being completely paralyzed, being rather mobile. But you should add anything you want to add at this point.
Does look like his drug case from 2003 got DD'd. I don't know what that meant.
Dead docketed. We don't DD anymore, but they DD'd back then.
I don't know, but it was a 03 SC case. I'm just curious because he tells me it got dismissed, like the Rabun County got dismissed, 03 SC 01937.
Okay, I'm not sure your point.
Because it looked like he had a drug possession case on his record, and he just took issue with that, and it got dismissed. It's so old,
It doesn't change a lot. And I'm looking at the recidivist notice or the repeat offender notice from the DA's office that got the case out of non-complex, and here it's a real old shoplifting felony from Cobb, couple drug cases from Fulton, the Walton case that continues to haunt him, and the Newton County shoplifting. But they're all old. They're 2018 cases. So Mr. Cook has either stayed out of trouble or figured out how not to get caught in the intervening years until July 14th, 2022.
the only thing I know is there ain't no way he was running out of that house.
I was going to ask him about that, what it meant to be trying to elude the police, because I'm assuming in July of 2022, you were less mobile than you are today. Okay.
Are we talking about the Raven case?
No, I'm not interested in the Raven case.
He was located in the backyard, Judge.
Pardon me?
He was located in the back of the.
Right. We're talking about this case, and the factual basis the state has provided is police get a search warrant, they show up, and people scatter. One of the scatterees was Mr. Cook.
Mm-hmm.
He's caught because he probably doesn't scatter as fast as other people. And then there are things that connect Mr. Cook to the room where the drugs and the gun were found. His pill bottle, his keys, or at least keys that go to a car that has his ID in the car. So I get it, and I understand why going to trial might not be a great idea, because the state's recommendation would be very different after trial. And I don't know that a jury would look past well, wait, the drugs were in the room with your pill bottle, not this guy's pill bottle or that lady's pill bottle. And why did the keys go to that ID? So here's where we are.
So, and you've heard he's 47 years of age. He was born in Atlanta, went to South Atlanta High School. He actually completed the 9th grade, but he got his GED in 2014. Didn't go to school beyond. In 1995, you heard about his drive-by shooting where he was shot in the stomach and the leg and the foot. And, was told he wasn't gonna ever walk again or have children or anything, so we know he did those odds. He has, been, married for 20, been with this, young lady for 27 years, married for 10 years, does have a 19-year-old daughter who's becoming an RN. So she's come to court and even, that, at least Adam, and some, when Ms. Davis was busy. I think it's a case went to trial, and the reason we're pleading, under offer, we asked it for, to make a case under offer. The case would show that granddaddy, owned the house, it was 10-room, rooming house.
Ms. Rockwell, please put the microphone in front of you.
It was a 10-room rooming house, and that room was his dad's room, Anthony Cook also. He was in the hospital, and Mr. Cook swears that you helped him get out in time for his dad's funeral. He
It's
was
nice of me if I did.
Yeah, you did that for another one too, remember?
You bring those kinds of issues into this courtroom.
At any rate, so he did tell me that that is where he would go to smoke crack cocaine. He got charged with meth. He said his dad, whatever, he doesn't need to go back there. And he doesn't need to, he said he's straight now on the drugs. And he's got the medication that he needs now, the fentanyl and the oxycodone. And he's got his check all set up and he's good. And he says he doesn't need to go back there. I would just ask that you accept it under offered, because there are some questions as to whether or not he was even in the backyard running, not running. I know he doesn't move very fast, neither do I. But I was concerned, he had that 2018 case, and he had one case was it in Newton?
In the Walton.
And then followed by the Walton case. But Madam Probation says that this plea will not revoke that, even though he was technically under sentence in some form or fashion. I'm still not 100% satisfied that his revocation, where he got 16 months, that started on July 2nd, July 3rd, he's still under house arrest, included this as one of the reasons. So I just want the court to, I probably never even thought about talking to the prosecutor about tendering a no-low plea. I don't want it to be a deal breaker. I just can't promise him, even though Madam Probation thinks that this plea does not complicate that 2018 plea.
So, Ms. Rockwell, as usual, is giving good advice, Mr. Cook. No one in this room can promise you that this plea won't create a hiccup well, let me pause. Is Mr. Cook on probation for both cases, Walton and Newton, or just Walton? Okay, so there'll be no impact in Newton. That case is closed out. How much time is left in Walton?
Walton expires January 9th, 2028.
All right, so you got a little more time left on that. Couple years. Are you able to see what the basis was for the Walton revocation?
The warrant, they didn't post a petition, but based on the warrant, it was just what they need to report.
Okay.
That's what he told me.
Yeah, that's a long revocation, at least in Fulton, to get.
He had the revocation hearing.
The prosecutor brought this stuff
It
up.
would have come up at the time of the revocation because the offense date for this case was before the revocation in Walton County, so it would have come up.
Okay.
So the revocation seems to happen July of 24. And this case did happen July the 14th of 22. And he's telling me, Mr. Cook is telling me that probation did also talk about this case.
Right, so it would have been an aggravating factor for the judge, and who knows whether the judge thought, well, I'm revoking you for both, or even spoke those words, but at least it was presented to the judge. Not only did Cook not report, but when he wasn't reporting, he's slinging dope on La Rosa Terrace and he's got a gun. And so it's a 16-month revocation rather than like a 3-month revocation for not reporting.
It was only just 1 year.
Oh, it wasn't 12 months?
It said he was provoked 1 year.
Okay. Where did you get to 16 months?
Because he sat for 4 months
Before I went to court.
before he went to court.
Okay, so going forward, it was 12 months of house arrest. Got it.
They told me they were gonna give me the whole 16 months. But when I called the lady and asked her when did I get off, she said November the 4th. And she said it ain't in there nowhere where it says that it's just from the day that I start court.
Okay.
Day of court.
That's right.
That makes sense, Judge. And it was July 2nd, he told me you saw July, or somebody saw July 3rd of 2024. But then he would have been done if it was 12 months in July.
Right. But either way, he's had more than a year linked to that revocation, which is what your sales pitch was to Ms. Davis and people on up.
And I see he does still have that ankle monitor on. He's got to stay on the porch, remember?
Oh, that's right.
Remember, he
Yeah.
said he could just go on the porch.
He spent a year on the porch.
And he loves to come to Judge Roberts' courtroom. So anyway,
Keep you entertained on the porch.
and on you watch him on YouTube?
I watched them on YouTube.
Yeah, we talked about that. We don't need to go back there.
Okay, hold on. So
So let me just finish then that thought. Mr. Cook, I do not expect this plea to result in any more trouble for you in Walton because of everything you've shared. But you need to understand that my expectation is not a promise. I can't,
Yeah, John.
you understand that? Understanding that, you still want to go forward.
Saying exactly what you're saying, cause they can feel like I just got another charge while I'm on probation. They can replicate me. I understand
Right.
where you come from.
But your lawyer there, whether it's Ms. Rockwell or someone else, would say, no, wait a minute. We talked about this back in 24. And the reason why it was 4 months in custody and 12 months of house arrest was it was more than just failing to report. Judge, you heard about this case. It's just Fulton moves slowly, and only now is Fulton dealing with this case. Even though it happened back in 22, it took them 3 years and 3 months to get it done. And they'll laugh at Fulton County, and they can do that. They're right. Okay. Anything else, Ms. Rockwell?
that's all. So I feel good about it too. Madam Probation also said the revocation or this case happened and the revocation was after. So Madam Probation also feels pretty good about it too.
This had been a known fact for 2 years. By the time of the revocation in Walton County, the GCIC showed this arrest. You had been in jail for a little while. You had a bond. You're basically out on bond for a bunch of felonies. Any probation folks worth their salt down in Walton would be saying, we also have this. And then the judge factored that in. Okay.
I'm just so it's okay if you tell me no. Would you allow him to enter a NOLO, Madam Prosecutor?
No, I won't.
Okay,
So we don't need
that's
to go
fine.
there.
Then you're the last one. So that I would just ask that this probation run concurrent with that probation. He's got about 3 years left, and I'm gonna come see you if God's willing in 3 years if he hadn't had a hiccup.
We'll work through that. Anything else?
That's all.
Okay. Mr. Cook, anything you want to add? Am I remembering you actually have 2 kids or just the 19-year-old?
I won.
The 19-year-old, where'd she go to high school?
She go Albany State.
So she's in college now, but where did she go to high school?
She went to Washington.
Okay, she graduated and she's now at Albany State studying nursing.
Yes.
How'd you do that? That's your daughter's doing well.
Right now.
All right, well, good for both of you, because that's a very different trajectory than you've taken. And I'm happy for her. Does she have kids?
No.
Good.
You don't got nothing going on.
Well, hopefully she's got nursing going on and maybe she's got friends at Albany State. That's all right. She's in college. How often does she come home?
She come on when you know, like when they get a break, when they have a break. And
Is she a freshman or a sophomore?
She's a sophomore. She
Okay.
finished the freshman stage.
Great. How's she paying for it?
She had got financial aid, and she had got a scholarship too.
Okay, so she's a Hope Scholar or Zell Miller or something.
And
Good.
we pay too. My wife, some kind of we got.
Okay, you're contributing some, she's getting financial aid.
Yeah.
It's working out though.
That's why I was so scared to get took out the home, because it was gonna make everything go crazy. And I could really do appreciate y'all for it, because if I get took out the home, my income get took out the home, and then it's gonna make it hard for her and baby to get buried.
Okay, well, I haven't sentenced you yet, so don't thank me yet.
No.
So when you say your income, you get SSDI?
Yes.
Okay.
It's I.
Okay, SSI. Either way, you get benefits
Yes.
because of your injury.
Yes, Judge.
Got it. Ma'am, do you work?
Yes.
Tell me what you do. A used car dealer. Okay. So 2 sources of income for the household, the used car dealership and the SSI.
Yes.
Okay. Anything else you want to add, Mr. Cook? Nope. All right. And you don't need to be back at La Rosa Terrace. If one of the conditions is stay away from there, that's that's family property. We go there for special events. Okay.
Not at all.
All right. Well, Mr. Cook, I find there's a factual basis for your plea. I understand that you challenged some of the evidence, and if there was a trial, Ms. Rockwell would do a good job of getting the jury to think about it in different ways. But if Ms. Davis proved up what she shared with me, a jury could find you guilty. Would they? I don't know, but they could, and that's why I'm accepting your plea. It's an offered plea, so you're telling me I don't think it happened the way the state did, but I, meaning you, Mr. Cook, think it's in your best interest to go forward with the plea. Is that correct?
Yes, Judge.
Okay. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And knowing means that after we've had this conversation, you feel like you understand everything we've been talking about.
I do understand.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rockwell, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Davis?
Yes, Your Honor.
And Mr. Cook, can we electronically sign your name to your offered plea?
Yes.
Okay, we'll do that. And I need to confirm, because I plugged in a little late on this, the medication that you take, the oxy, the fentanyl, et cetera, when do you take it?
I got an appointment to go back to I take it every day.
Every day,
Yeah.
morning or night?
I take Oxycontin 4 times a day. I get to take it 4 times a day, and my patch stays on. I just put the patch on and it stays on.
The patch is fentanyl.
In and out. I'm gonna get another one. I go back to the doctor in 2 days.
Okay. Did you get medicine today?
Yeah, I had my medicine before I left home.
Okay. When you take that medicine, does it make you confused or woozy or disoriented?
It take my pain away. It's
Okay.
a pain blocking medication.
You don't feel like it's affecting your ability to understand?
I start my behind and my legs from hurt.
Okay. I don't want either of those to hurt right now. Mr. Cook, I will follow the negotiated resolution, and on count 1, I will sentence you to 3 years to serve 1 year with the balance on probation. I'm going to need Ms. Rockwell to get documentation of your revocation in Walton. And it may be Ms. Simpson can send it, but it's that revocation order. I just need to see that you actually got revoked for that time, and I will treat that house arrest as that year in custody. Okay? And so Ms. Rockwell can work with Ms. Simpson. Someone needs to send to Ms. Nelson proof of that situation. Count 2 has to be 5 years, has to be consecutive to count 1, but I'll probate that. And count 3 will also be 3 years. Oh, nope, it has to be 5. It'll be 5. Oh, so does count 1. That's complicated. All right. Sorry, Ms. Nelson. We have to restructure this. Count 1 is 5 years to serve 1 year with a balance on probation. Count 3 is 5 years to serve 1 year with the balance on probation. Those are running concurrently with each other. Count 2 has to be consecutive. The first 3 years of count 2 are probation. The last 2 are suspended. So your total sentence is actually 10 to serve 1. The 1 year is that house arrest. Then it's going to be 7 years of probation. That gets us to 8. The last 2 are suspended. No probation, no supervision, nothing. But because of what you got charged with, it actually has to add up to 10. I can't go below 10. The only condition of your suspended sentence, those are those last 2 years way out there, is that you obey the laws of Georgia, all the other states, and the United States. In other words, don't get arrested. If you get arrested while you're on a suspended sentence, the state can come back here and get those years revoked. Special conditions of your probated sentence, that's basically the next 7 years. Number 1, you forfeit whatever was seized in this July arrest. Don't go back to APD and say, I want the guns, I want the drugs, I want whatever they seized. That's forever gone to you. You will stay away from La Rosa Terrace. And you will submit to a drug and alcohol abuse evaluation so that a medical professional can talk to you and make sure that your usage of the oxy and the fentanyl is in fact medically justified. I don't doubt it, but I want another person just to be making sure, what, man, he should be done with oxy by now. Or look at that, he gets 6 prescriptions during the time he really only needs 1, and so he's abusing that medication. And if they think you need some treatment, they'll do that. But I think you're in a space right now where your medication is being carefully managed and is being used to do exactly what you said, which is to make your legs and your behind not hurt, or at least hurt less. I hope someday you don't need the medication, but that's about healing and progress, and we'll see what happens. It's not a condition of your probation. You will take medication as long as it's prescribed. The final special condition is no unprescribed prescription medication. In other words, if you're taking pills and you don't have a script for them, that's a violation of probation. Okay?
Yeah.
Any questions about that?
No, John.
Ms. Rockwell, anything else from the defense?
No, sir. Just, was the court inclined to run it concurrent and,
Oh, yeah, it's concurrent with any other existing sentence. So I know you've got a little probation, actually, 2 years plus probation out of Walton. This probation starts as soon as I sign the sentence. I'm not going to sign it till I see that proof of the year's revocation. But I'm confident that's coming in just a few days, if not today. So you will have for a few years probation, Walton and Fulton. It's all supervised in one place. You don't have to go to 2 places. But this is a longer sentence, meaning it will go further on. So there'll be a point where you're done with Walton, just like you're done with Rabin now, but the Fulton will keep going. Okay? Ms. Davis, anything else?
No, Your Honor.
Ms. Simpson, how does reporting work for Mr. Cook since he's already on probation?
He would just need to get in contact with his officer within 48 hours.
Do you know who your probation officer is?
Yes.
Okay. So by next Tuesday, you need to have called your officer saying, hey, I pled, I've got these new charges that'll be on probation.
Okay.
And it'll all be in the system. Ms. Simpson or someone will have put something in the system. So your probation officer will be looking like, all right, look at that. You got to stay away from La Rosa Terrace, blah, 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 all that stuff.
could Ms. Nelson maybe put somewhere the offense date on it? I'm going to give him a copy of the indictment and the disposition. That might not. Oh,
Will be in the system.
okay, because she can see that he got arrested and then his revocation was in Walton was after his arrest date.
Right, but that's all things you can get because it's in the docket. You can get Mr. Cook a copy of the indictment, which will have the incident date, and they'll see that was 2 years before the Walton revocation.
Okay.
And
I was actually looking, the offense date for this case was before this Walton case even started, so it doesn't even actually.
well, I'm confused by that because the Walton case is a 2018 indictment.
He was sentenced in 2018, but according to this, his probation for it didn't actually start until 2020.
Oh, well, there's an additional argument then that your lawyer may have. Did you get arrested in Walton, but then you didn't plead for a whole bunch of years?
I had a case in Walton County and a case in Newton County, but it's the same judge circuit, so they just handle all the cases in one.
Okay, but was it just a whole bunch of years later? Maybe they're slower than we are.
One over there and left, one over there, and then after they finished sentencing me, they just went back and got that one. My lawyer said, he said, no, since you're going to plead out in this one, go to prison and then come back, you're gonna have to go back over there. So he said, let me go get the case, and he ran it in together.
Okay.
No, he didn't run it together. He ran it behind it.
Okay, then.
Oh, so it was a consecutive sentence?
Yes, it was. He ran it behind it. Like
Okay, so he may have
he
pled.
probation, and then I got, after that one was in it, I had to start the second.
Yeah, he made the, one of the counts, consecutive.
Got it.
He's actually technically serving one of the consecutive.
Got it. Okay.
I always feel like though, you're still under sentence.
Yep. Okay. Well, I think, again, it's merely my expectation, not my promise, that today's plea is not a tripwire for more revocation out of Walton. And I think there are probably a couple things your lawyer will be able to point to. One, your big old revocation you already had. And two, technically your sentence didn't even start until after this offense conduct. And you cannot be revoked for something that happened before you got sentenced. But that's a little murky to me, what went on down there. Every county is different. That's one of the beautiful things about Georgia. All right, that is it. Thank you so much, Ms. Hardy, for filling in. You have a great weekend. Thank you, Ms. Rivers. We, in theory, have jury selection on Monday, so will we see you down here?
Yes, you will, Judge. Have a good
Great. We'll have a good weekend.
Okay.
Yes, I do. 519 Harper Road, Atlanta, Georgia. Yes, everything. My probation officer come to my house. Yeah,
So the number ending in 238.
yes, that's my phone number I have.
Okay.